I am Chris Jones from Pepper Hamilton. Welcome to our Pepper podcast. I am interviewing my partner, Mike Baughman, today about the Sixth Circuit's December 12th decision in the Kollaritsch versus Michigan State University case. Mike represented Michigan State University and is going to start by telling us about the importance of that decision.
The case is important because it clarified a question that has been percolating in the courts of appeal about the scope of liability under Title IX and whether or not colleges and universities are liable for how they respond to a single instance of sexual misconduct, student-on-student sexual misconduct.
How did they resolve that issue?
The court found that a school can't be liable for damages under Title IX unless its response to a incident of sexual misconduct is not only deliberately indifferent, but its deliberate indifference causes the student to suffer additional harassment.
Mike, if a student doesn't like how the school's Title IX process addressed their claim of sexual misconduct, do they have a cause of action under Title IX for damages?
Not unless the response caused them to suffer additional harassment. At least that's what the Kollaritsch case says.
Mike, how did the Kollaritsch case get to the Sixth Circuit?
Well, we filed a motion to dismiss the complaint, arguing that the plaintiffs had not pleaded that they suffered additional harassment, and then the district court denied that motion, but we filed a motion to certify that decision for an immediate appeal to the Sixth Circuit, which the district court granted, and then the Sixth Circuit agreed to hear the case, and then we briefed the case on whether or not the district court was right or wrong in denying our motion to dismiss.
What were the plaintiffs alleging, and why did Michigan State feel that was insufficient?
So the allegations in the complaint, there were three plaintiffs who made their way up to the Court of Appeals, and each of them took issue with how the university responded to their reports of sexual assault. They argued that the university took too long, that the university didn't take sufficient steps to segregate the assailant and the complainant from each other on campus, and they took issue with sort of the particulars of the process. What they didn't allege was that after they reported the assault to the university, that they suffered additional harassment. So, for example, for two of the plaintiffs, they didn't actually see the assailant on campus again. They never saw the assailant again after they reported the incident to the university.
If they weren't alleging additional discrimination, what were they alleging were their concerns after they made their reports to Michigan State University?
Right. So their allegation was that by the continued presence of the assailants on campus, that in and of itself constituted discrimination, and that by allowing the students to remain on campus and not more promptly addressing their complaints of sexual misconduct, that's what they said violated Title IX.
That they were vulnerable to further harassment.
Correct. And the decision goes off on, I think one of the reasons I think the decision is important is that all of this started with a case in the U.S. Supreme Court called Davis versus Monroe County. And that is the first and only time that the Supreme Court has talked about whether Title IX allows you to sue for damages when one student sexually harasses another student. And in that case, the Supreme Court was very clear they were creating a very narrow cause of action. But there was a specific dispute as to a particular portion of the decision that talked about causation. And in particular, the Supreme Court said that the school's deliberate indifference has to subject the student to harassment. And in defining subject, the Supreme Court said that has to either cause harassment or make the student more vulnerable to it.
What did the plaintiffs argue that language meant?
Right. So they argued that by an unreasonable response to their report of sexual misconduct and not taking more prompt action, they were more vulnerable to harassment because their assailants were still on campus and they might see them again. And what the Kollaritsch court said, well, let me back up. There's been differing interpretations of what that sentence in Davis means. So some courts have said that that's sufficient if there's a risk of seeing the assailant on campus. That can make you more vulnerable to harassment. So the Kollaritsch court said that's not sufficient. In order to hold the school liable for harassment, the school itself has to subject the student to harassment, meaning that the school's deliberate indifference has to cause harassment after the school becomes aware of it.
So are we to understand now that, at least in the Sixth Circuit, there is a requirement that in order for a student to sue for damages under Title IX, they have to suffer actual additional harassment after reporting sexual misconduct to the school?
Correct. So I think the takeaway point on the case is it's not sufficient. You can't sue a school simply because you're dissatisfied with the way the school responded to a report of sexual misconduct. Instead, you can't argue it took too long or you didn't do things that I wanted you to do during the course of the investigation. Instead, you have to show that the school's conduct is what subjected you to harassment, meaning the school did something either by act or omission which caused you to suffer harassment.
What would be an example of additional harassment that might state a claim under the Kollaritsch standard in the Sixth Circuit?
So I think actually the best example is the facts of that Davis case from the Supreme Court itself. And that involved sort of an ongoing course of conduct by a student where over many months, one student was making repeated sexually harassing comments to another student, engaging in all sorts of misconduct over a long period of time. The parents repeatedly told the school about it, but the school did almost nothing about it. So in that situation, the school had knowledge that there was harassment that was ongoing, didn't do anything to stop it, and allowed it to continue. So that's, what we argued in the Kollaritsch case is that's what the Supreme Court had in mind when they issued the Davis case, is ongoing harassment that the school is aware of, that it doesn't take measures reasonably calculated to stop, not how it responds to a single instance of past misconduct.
Would it be fair to characterize the Sixth Circuit's holding as a narrow interpretation of what will constitute a private cause of action for damages under Title IX?
One could interpret it as narrow, or one could interpret it as that's what the Supreme Court had in mind in Davis. And in Davis, the Supreme Court said that the cause of action that they were creating was narrow. And in fact, one of the judges in the concurring opinion, Judge Thapar, emphasized that if you actually read the Davis case, they were very careful to make clear that they were not creating a broad cause of action under Title IX.
So, Mike, how does this Sixth Circuit decision fit into the overall national landscape of Title IX jurisprudence? Where are we at?
I think there's a circuit split right now. The Sixth Circuit specifically rejected another decision that came out earlier this year from the Tenth Circuit, Farmer versus Kansas State University, which had agreed that vulnerability to harassment, meaning that you might see an assailant on campus, is sufficient to state a claim under Title IX. So I think it creates a circuit split.
For colleges and universities, Mike, what is the upshot of the Kollaritsch decision, both within the Sixth Circuit and outside of the Sixth Circuit?
So I really think it's a question of what schools might be liable for in damages. That's really the only question that was decided in Kollaritsch. The question was whether or not there is a damage claim, meaning that schools can be sued in court for how they respond to allegations of sexual misconduct. I don't think it should change the way schools handle Title IX matters on a day-to-day basis. I don't think schools should change what they're doing. But what it does establish is that schools can't be liable simply for the way that they might respond to a allegation of sexual misconduct.
So, Mike, if people listening to this podcast want to learn more about the Kollaritsch decision, where can they look?
Well, you could read the entire decision, or we've done a summary of it, which is available on Pepper's Insights Center.
Great, thank you.